where Annette had advised her membership via email of a bill in Minnesota, that one of the things this bill was doing, in addition to trying to overhaul the entire debt collection ecosystem, specifically with respect to post judgment, but they were trying to change the definition of a debt uh, to include small businesses of a debtor. So they were trying to say that small businesses should be governed by their legislation. Clearly, that would have impacted every single one of us on this call for a variety of reasons. Thankfully, that did not make it to the final bill. We'll talk more about that. But the Minnesota effort is not alone. There is some history with federal stuff that's trying to do that as well, which we'll talk about. So, in the past, everything was federal. There was no discussions about a state level. People weren't looking at a state level. And in fact, we've got the Consumer Financial Protection Bureau, the CFPB. They're out there. They would love to include small businesses. There was legislation a couple years ago that was HR 6814 back in 2022. It was a bill proposed to include small businesses in the definition of the FDCPA. So what was happening in Minnesota was not new. It's not something that was fresh and wasn't without thought. This is something that the CFPB has been trying to do, and based on recent events with the CFPB, where there was a Supreme Court decision that confirmed their ability to operate in the manner they operate and really gave them a lot more power. And we're going to see more effort by the CFPB in terms of expanding their oversight of different groups, different people, putting in place different regulations. So it's something that we all have to be aware of. I had the good fortune or not of actually visiting the CFPB a few months ago. It's very interesting. They got a big, beautiful building in downtown DC, massive. I had to sit down in the lobby for about 20 minutes or so while they ran all of our information, make sure we were legitimate, and they got the people who we were meeting with. In the 20 to 30 minutes I was sitting there, I didn't see one person walk by me. I don't think anyone's working in the building. I mean, I think they are all working virtually. So, there's our government in motion, and spending all this money on this prime piece of real estate in downtown DC, and nobody was there. So CFPB continues to be active. They came out with Regulation F recently, and that was an amendment to the Fair Debt Collection Practices Act. And really, it clarified some things. So in some ways, it was good. In other ways, not so good. But it really dealt with all efforts um, to with consumer interaction and communication. Once again, all consumer, but what is a consumer? Are you dealing with some sort of a debt that it's questionable what it was? So we all have to be careful. We all have to be mindful in that context, that we know what the debt is that we're pursuing, because there's a lot of landmines out there to try to bring you in the commercial front. Some of those are just one-offs, attorneys looking for lawsuits. Others are from a more aligned approach, from a legislative approach, whether it's from the federal level or the state level. So as we talk about, and by the way, if anyone has any questions as we proceed, I didn't mention, feel free to put it in the chat or chime in, raise your hand, whatever. I'm fine with answering questions throughout. Certainly not going to trip me up, so I'm happy to do so. Well, what we're seeing is we're seeing that the landscape has changed. So, like I said, while there's a lot going on at a federal level, it's really been taken to the state. And what's happening is there are some very active consumer groups out there that are very well funded, that are sponsoring legislation, whether it's through traditional legislative models or through referendums and propositions where they're going directly to the voters. And they are changing the landscape of post-judgment collections. So these groups are the Pew Charitable Trust. If you've got a little bit of time, you can Google them. Very interesting. They have a boatload of money, and they are very active. And then you have the NCLC, which is the National Consumer Law Center. Once again, very active group, well funded, very cohesive. They work together, both of these two groups, on a lot of the legislation that is impacting our industry, from giving credit to all the way through to collecting post judgment. And a lot of the stuff that we see starts off with a lot of it starting off with this idea that they're attacking medical debt. Okay, and that's been kind of like the theme. But it's really way more. So when they talk about just attacking medical debt, it's just a way for them to get the door open and to get people. It's juicy. Nobody really likes to hear about medical debt. You know, if somebody's got medical debt, there's a good chance they really were in trouble, right? So it's a way to get everyone to really listen up and get engaged. So um, what happened is, these groups were involved backing a group out of California that ultimately ended up um, putting forth a proposition in Arizona, which we'll talk about in a second. That was kind of the first opening our eyes to what's going on at a state level and what's being mimicked around the country now, what took place in Arizona. And all these efforts are essentially trying to um, they're trying to reduce the amount of money subject to employment garnishments. So they increase the amount of money that is excluded under an employment garnishment, and then they reduce the amount that is subject to the garnishment. Traditionally we've seen it's been 20 times minimum wage, and then 25% of anything over that. And now there's stuff coming out where they're increasing these proposed exemptions to 50, 60, 70 times and limiting it down to 15%, which, as I'll share with you and show you, almost makes it where there's somebody making $80,000 a year is probably going to be exempt from garnishment under some of these models. So they attack employment garnishments, they attack bank garnishments, they increase exemptions. So not every state has exemptions when it comes to a bank garnishment. Pretty much every state, because there's a federal rule, has an exemptions around employment garns, but not every state has an exemption around a bank garnishment. So they'll go and they'll when they do some of this legislation in some of these states, like in Arizona, and they'll put in place like a $15,000 exemption so that the first $15,000 in your bank account is exempt from garnishment. Well, I don't know about you guys, but rarely do we see garnishments actually get anywhere close to $15,000. So bank garnishments in that scenario would almost be non-existent. The idea of getting a bank garnishment on somebody is going to be pretty difficult. So and that's their goal, right? That's the goal of, and I'm just going to say it, it's the goal of the left. Most of the legislation we're going to talk about and that is out there, you look at the states and it is absolutely divided by the political climate within that state. If you are in a state that has a Republican climate, chances are you're not going to see a lot of these proposed legislations happening. You're in a state that has a Democratic climate, you are going to see it happening. And that is the way of the world, and that is kind of how it is. And which is why it's so important too, from an advocacy standpoint, that as an association, as a group, individually for your businesses or those of you that are involved in some of the management of your businesses, that everybody understand and do what they can to support advocacy efforts within our industry, because we are under attack. There is definitely efforts to erode our ability to collect money. And the only way we can fight those is by having a seat at the table. And the only way you're going to get a seat at the table is to have funding to support your efforts. On a federal level, there's a vehicle called a PAC, a Political Action Committee. A lot of associations have these set up, and those PACs can be used to lobby at a federal level and go to fundraisers for Congress people or senators and let them know who you are and make sure they know who the association is, and have that seat at the table so you can try to get their ear when you're trying to make a difference. Uh, Likewise, some sort of advocacy support funding, equally important to be able to have money at a state level and know what's going on. Because what's happened is some of these states have been blindsided. Real quick, going back, I talked about employment bank garnishments. They're also trying to property liens. Right now, there are some states they have varying degrees of exemptions with a property lien. So maybe the exemption's 15,000, maybe it's 50. Some of these states are trying to put in place where there's $250,000 exemption. So if you have a house that's worth $300,000 and you have $200,000 in equity, that entire $200,000 is going to be exempt from all of your creditors being able to get to that money. So essentially, it's, somebody can live in in a pretty nice house and get away with not having to pay any of their bills, and all that money will be exempt. Um, they're also trying to reduce the life of judgments. So every state's different. This is all state controlled. One state may have a judgment that is good for 10 years. One might have 5 years, and then you have to renew it. One might have 20 years. They're trying to go in a lot of these legislations and reduce the life of the judgment. And this is an attack on just the debt collection world, right? If you are filing a lawsuit that is just a contractual dispute, you are treated different than the lawsuit that you are filing because it's a debt collection lawsuit. So we are being signaled out and treated differently. So definitely some disparate treatment being given here, but it doesn't really work to try to claim that they do it and they get away with it. Also, reducing statute of limitations. A lot of this has happened along some of these efforts to reduce statute of limitations. So, contractually, you'll find that states have typically statute of limitations anywhere from 3 to 6 years, where if the obligation arose at a period beyond that statute of limitations, you're barred from going after it. There are some states where if you get a payment in the middle of that period, that will toll the statute of limitations. Some of these efforts, they say no, if you get a payment that's in the middle of that statute of limitations period, it does not toll it. And they're saying that, hey, yeah, in the past, we've had a statute of limitations at 6 years. No, we're going to make it 3 years for debt collection. So signaling out debt collection. So we're seeing a lot of that. So it really started going to the state level a couple of years ago. Arizona was kind of the first one, and I mentioned it. This group out of California came in and funded this whole referendum, and it was called Arizona Proposition 209. And the title was the Predatory Debt Collection Protection Act. And it was sold as a way to stop people from having to, for their lives to have to be ruined for their medical obligation, their medical debt that they had. But it went way beyond that. It did all those things that I just mentioned. And unfortunately, it kind of came out of nowhere. The creditor and collection bar in Arizona, the people in that realm got blindsided by this proposition. Nobody really realized that it was coming. It was very fun. We got a question here from Matt Garcia. Remember, not all states allow payments to toll the statute of limitations, and Texas is one of them. So right in line with what I said, that's true. Not all states do allow that, and some states that did allow it are trying to change it. So in Arizona, it came out as a ballot initiative.
Excuse me, Michael. Do you want to
Yeah,
explain tolling so everybody
sure.
understands that?
Absolutely. Sorry. So, in a situation where a state would allow the tolling of a statute of limitations, if the statute of limitations started, let's say the debt accrued on January 1st of 2020, and it's a 6-year statute of limitations for a contract. Well, let's go back to January 1st, 2018. And technically, that statute would be blowing now because we're 6 years past. However, in January 1st of 2021, that debtor made a $100 payment on that account. And in some states, you can use that payment to toll the statute and start it running all over again from that payment date. Okay. So a lot of efforts to do away with that. So Arizona Prop 209, it passed, and it was huge. Now, there are only, I don't know how many states, but most states don't allow you to go directly to your voters with a referendum with proposition. Arizona actually is one of those. Michigan happens to be one of those. We're going to talk about Michigan in a second. This caught the Arizona creditors by surprise. It changed the landscape. It has definitely limited their ability to collect post judgment. The attorneys in Arizona are getting around it. They have found ways to try to collect money, but it's never going to be like it was. The ability to collect money in a post judgment environment in Arizona is gone. And what's happened is, obviously, when you win once, you get power and you try again. So these between the NCLC and the Pew Family Trust, they're going out there and trying to put forth this the same mindset, whether it's via legislation or proposition in different states. So this is happening in a lot of different states. Minnesota was one of them I mentioned. Minnesota, what happened, and this is really what has to happen. Minnesota, there was a group came together, and they started negotiating with the state, with the legislatures, and they were able, one thing, to get rid of that attempt to keep small businesses in as subject to the act, or subject to a consumer debt. That was a good thing. And they were able to negotiate some of these things from, and I don't have the exact details, but let's just say there was there might have been a $200,000 $200,000 in a lien. I'm having a mind blank here, but anyways, they came in and they negotiated. Okay. And so the exemption, so the $200,000 exemption was there. They negotiated and maybe they agreed to 50,000. So that's really what's happening around the country. And so that takes us to Michigan, which is where I am located and which is probably at the forefront right now of one of these efforts to try to change the landscape here. So in Michigan, they are able to go in a proposition, a referendum directly to the voters, but they chose not to. They actually got together with some legislatures, a House bill or Senate bill rather, 408 and 409. 408 deals with debt collection, 409 with bankruptcy exemptions. They were put forth. There was a lot of involvement. There were groups came together. The local bankers, Michigan Bankers Association, our Chamber of Commerce's, our Michigan Creditors Bar Association, the Credit Union League, all these different people came together and started fighting together. Some of that fighting has been working, and there was some change made, but the changes have been pretty not enough. And right now, I mean, the changes in Michigan include wage garnishment exemptions, judgment liens, a 90-day look back for financial institutions on bank garnishments, where they have to go back and see whether or not the fund should be exempt, which puts a huge burden on the banking community. They certainly don't want that. Motor vehicle exemption up to $25,000. So if you try to levy on a motor vehicle, the consumer can keep the debtor can keep their car up to $25,000. Increased homestead exemption up to $250,000. Bank garnishment exemptions up to $17,000. And remove in Michigan what we have, which is state income tax garnishments, which is pretty huge. So there's heavy negotiation going on. It's not expected that it's going to pass right now. As of right now, there was a committee. They were meeting with some of these other stakeholders, and they've kind of gone silent while they're out on summer break. So nobody really knows what's happening. But our legislature here in Michigan, both our Senate and our House, is Democratic controlled, but only by 1 or 2 members in each one. And I gave an example to Umberto and Annette early on before we started today, that someone through the Michigan Creditors Bar Association, as we were doing some lobbying, went to a House member who was a Democratic House member in the city of Detroit and explained to him what this act looked like and how it was not good for the consumer, and how it was horrible for business, and explained to him It turns out that he is a small business owner. He owns a handful, 10 to 15 residential properties in the city of Detroit. And they explained to him that you realize that if you get a judgment against one of your renters because they don't pay, you will not be able to collect. And he was incredulous. He couldn't believe it. And he said, well, this is stupid. So you just need one or two people like that. I told Annette and Uberto one other story. Someone I know, super liberal left House member, happens to be my House member. I know his family. I know his father's a doctor, lives in a $3.5 million house on a lake, has a huge sports medicine, physical rehabilitation practice. I set up a special meeting with him and I said, you realize that if your father gives someone services, in this context, and if this law passes, you will not be able, your father will not be able to collect the money he's owed. So he got it, and he's like, "Oh, well, that's not right." So it's a grassroots effort, as we're doing in Michigan, hitting one by one. But at the end of the day, we know, and our hope is that it does not. We don't want it to go to a proposition because we'll lose. It will lose. We will not be happy. So the goal is to do a little horse trading and to try to negotiate with all the stakeholders and try to come to a conclusion that everybody can live with, that we can still collect money in the state of Michigan, that we still have decent debt collection laws, but that some have been updated, some of these exemptions. The people of the state of Michigan will be well served by their legislature doing great things for them. And and we can all keep going about our day and doing business. But this stuff is continuing. I just want to mention really quick the I mentioned District of Columbia. In the middle of the pandemic, District of Columbia put in place some emergency rules regarding debt collection. They kept them in the post-pandemic, and essentially debt collection from a litigation standpoint in the District of Columbia has ground to a halt. There is none happening. So that's all I got. I appreciate all of your time. I think our 20 minutes is up. If anyone has any questions, by all means, happy to answer them, but I really appreciate you taking the time to listen today.
Hey, Michael, I have a quick question.
Sure.
Do you have any insight into how the CFPB is looking to define a quote unquote small business?
I don't. I mean, there have been stuff that they've gone through in the past. I know that is on Chopra's site from, Chopra's the director, and he's mentioned it in the past. And right now, as it stands, they've got a lot of power and a lot of leeway. I know they'll keep trying, but I don't know what their definition will be.
Michael, can you clarify, when you're talking about the exemptions, are they commercial and consumer?
So they would be against any individual who you have a judgment against. So as I said early on, right, if you got a personal guarantor or you took a judgment against an unincorporated entity where your judgment is against individual A, once you got a judgment, they're not going to differentiate between whether or not that debt was a consumer debt or a commercial debt. So if you've got an obligation that somehow you're going to end up with a judgment against an individual, you are in the exact same boat as if that debt started off as a consumer debt.
For those that sit on a legal or a post-judgment desk at an agency, the $15,000 exemption on a bank garnishment, that's severely impactful. It's hard enough to get clients to sue. To traverse that, once you've got a judgment and you hit the bank and we're all happy when we hit the bank on a garnishment, and then to find out that there's an exemption, that's tough, man. And then you got to explain it to the client too.
Yeah.
Exactly.
And I know, and for the record, I know I went a little fast, but I felt I had a lot to get in there, and I only had 20 minutes. So if anyone has any follow-up questions beyond today, feel free to push them out to Annette or to me directly, and I'm happy to answer away. So I do feel like I rushed a little, but I had a lot to get through, and I wanted to make sure I got to it.
So there is a question whether the information will be provided for future reference. What the association is going to do is create a library of our 20-minute talks. And like I said at the beginning, this is the third 20-minute talk that we've had. Todd Gerstel talked about Minnesota. Peter Helt talked about Washington, D.C. and Maryland. And now Michael, who has not only given us a perspective on Michigan, but also, stuff coming from the federal and really being pushed down to the states. So are there any other questions that we can ask Michael at this time? Just you can just unmute yourself and ask the question.
Well, Michael, is there anywhere in particular, if we want to read up on these things or keep current with the legislation, where we can go? Is there a specific website site specific to the state? Is it something in general, or we just call your office?
You can always call me. I'm not aware of anything that is out there that is that is tabulating from a state level all the different stuff that's going on.
Mm-hmm.
I know that NCBA is trying to do that and trying to work with some other stakeholders in that realm. So I'll see what I can do if there's anything, some of the things that Annette and Umberto and I spoke about early on was trying to see what synergies there might be. The old school days of this group being against this group are gone, right? We all have very similar objectives, and we should all work together for the good of all of us in our organization, in our industry. So I talked to Annette about trying to perhaps do a little bit more with us, trying to share wherever we can, and let me see what I can do about that. So
Very helpful.
And
Thank you.
yeah, and for those that were around during the pandemic, we would have multi-association task force, and we had some of the stuff that was coming out from the federal on the federal front. We had to fight and have a coalition between a number of associations because it's very expensive. Michael was talking about a lobbyist costing $12 to $15,000 a month.
Yeah.
And that's very expensive.
and
I
that's just a
probably should have
federal.
become a
That's a federal lobbyist. I mean, if you had to go at a state level and get a lobbyist in every state, you couldn't. It would be unbelievable.
Mhm.
yeah. And the two organizations that you talked about, the consumer groups, the Pew and then the LC
NCLC.
NCLC, are there more of those that are focused on this, or is it really limited to those two?
I think they're the two driving forces right now. So there, if you go, I know I was like looking at early today, I was on the NCLC website, and their first thing there, it comes right up. Wait, National Consumer Law Center. As soon as you open it up, support the medical debt credit reporting ban, right? And everything about it, you go on and it just tells you about all their initiatives that they're doing, and they're hitting everything everywhere. If it deals with protecting an individual, what they consider, they are obviously consumer focused. They're out there and they're well funded. And Pew has tons of money, ridiculous amounts of money.
Who's funding them, Michael?
Well, it's Pew. It's a Pew family. I don't know where. I think it came from this Pew family. I think that's where the money came from. There's been other comments that George Soros is out there funding some of this stuff too. Who knows? I don't know.
Is that the same entity that does Pew Research?
Yeah. Yes.
Really?
Huh.
Okay.
Okay.
Wow.
Any other questions for Michael? It's very gracious to say that we could contact him. You're certainly able to contact me. I put my email in the chat. Michael, on behalf of the Board of Directors of CCA of A, this is the largest audience we've had. So we will thank you very much. This was very valuable information. We will be posting it on our website. We're going to create a library of our 20-minute talks, like I said. So give us a little bit and we will put that up on the website. And if you don't have a login to the website, please just go on the website and ask for a login. You'll be given one. And any additional questions? I don't want to cut anybody off.